known as a little bit more progressed than how it is in Australia. It's a real pleasure for me to act as your chair today. A little bit about Sue and then a tiny bit about me thereafter. So Sue is well known to very many people, I'm sure, on this Zoom. She is the director of boutique law firm Sue Barker Charities Law, which she founded in 2012. A brave move, I think some of us thought at the time, except that we knew who Sue Barker was, her love and passion for the law of charities, and her determination to succeed. And that success saw her, for example, in 2013, winning the Boutique Law Firm of the Year and indeed Tax Law Firm of the Year as runner-up in the New Zealand Law Awards. She is a co-author of the leading text in New Zealand, The Law and Practice of Charities in New Zealand. She is a contributor to Regulating Charities, The Inside Story, and she is a member of the core reference group for the review of the Charities Act. In 2019, Sue was awarded the New Zealand Law Foundation International Research Fellowship. I'm the chair of that organization. We awarded her that fellowship because we wanted her to undertake research into the question, what does a world-leading framework of charities law look like? Well, as many of you will know, she has been working very purposefully, despite the best efforts of COVID, on producing an answer, at least her answer to that question, and released last month her report called Focus on Purpose, in which she makes 70 recommendations for charities law reform in New Zealand. It's a delight for me to be able to chair the session today. In addition to my role as chair of the New Zealand Law Foundation, which is a large charity devoted to encouraging independent research on matters of legal and socio-legal concern in New Zealand, I, for my sins, am also a practitioner in the area of trust, estates and charities. Sue is seen by all of us practicing in New Zealand in the area as being our goddess. She is a huge contributor, both in terms of intellectual thought, but also of energy to work that needs to occur in our area. And she has been the standard bearer for the issue of reform in New Zealand. Sue, can I pass the microphone to you and ask you to please talk to us on your topic?
Thank you so much, Andrew, for that very kind introduction. Thank you also to Ian at the team at the Charity Law Association for hosting this webinar. Tēnā koutou katoa. Hello, everyone, and welcome to this discussion about what a world-leading framework of charities law might look like. I'm just going to quickly share my screen, which unfortunately causes just a slight delay. I'm sorry about that. So hopefully that will go into slideshow. Here we go. So, and thank you also very much to the New Zealand Law Foundation, Te Manatua Ture o Aotearoa, for granting me their 2019 International Research Fellowship to Karahipi Rangahau Aotaio to undertake research into the question, what does a world-leading framework of charities law look like? I am very grateful to the New Zealand Law Foundation for their support of this work, not least because it says that the charitable sector matters and it is worth taking the time to try to get the legal framework for charities right. I would like to approach today's discussion in three parts. I have been asked to talk a little bit about the government's review of the Charities Act in New Zealand. To set the scene, the review has very much been the backdrop to the report, and an understanding of where we've come from and how we've got to where we are, I think, is important in evaluating the current position and whether it needs to be changed. The second part is to discuss the report itself to the extent that that's possible in the time available. If you've had a chance to have a look at the report, you will see that in the executive summary that there is no executive summary. The push to distill complex issues into easily digestible sound bites, in my view, do charities an enormous disservice and contribute to their being overlooked, undervalued, misunderstood and dismissed with a once over lightly. Yet, the issues in this area of law go to the heart of the type of society we want to live in. It is very important, in my view, to get the legal framework for charities right. I know that the report is book length, and I know that everyone is very busy, but I would encourage you to read it nevertheless. Charities are worth it, and people do still read books. don't they? Having said all that, and then having necessarily given the report a bit of a once-over lightly myself and the time available, I am hoping that there will be time for questions at the end. I anticipate a robust discussion, and I genuinely don't mind if you disagree with me. You'll see in the first sentence of the report that charities law can be contentious. I passionately believe in freedom of expression, and that in a liberal democracy, it's through the discussion and the thrashing out of ideas that we get better results. So please ask, don't hold back. So let's have a quick whistle-stop look at the review of the Charities Act. It's important to note that prior to the Charities Act, charities in New Zealand enjoyed high levels of public trust and confidence. Public trust and confidence in charities does not derive from the Act. But the problem the Charities Act was trying to fix was a lack of information. IRD, the Attorney General, the public, nobody really knew anything about charities. So the Charities Act itself had a long gestation and was preceded by a number of reports, one of which was the 2002 report of the Working Party on Registration, Reporting and Monitoring of Charities, which is an important report to have a look at because it ultimately led to the Charities Act. The Working Party recommended establishing a single body, a Charities Commission, structured as a Crown entity, responsible for the registration and monitoring of charities. In making this recommendation, the Working Party specifically considered an alternative option of a business unit within an existing government department, but specifically rejected that option, arguing that it would be considerably inferior to a Charities Commission, as it would not have sufficient status and independence to gain the support and sense of ownership required from the charitable sector. It would fail to recognise the independence and importance of the charitable sector, and these issues would impact significantly on its role. However, in case its recommendation for a Charities Commission was not accepted, the Working Party also considered where such a business unit might be placed and specifically cautioned against locating it within the Department of Internal Affairs. In addition to administering the Charities Act, the DIA oversees approximately $650 million worth of grants and funding through Class 4 gambling activities, lotteries, profits, and a number of other funds. A large number of registered charities also receive funding from the DIA. All of this is important because a business unit within the Department of Internal Affairs, a government department, is exactly what we have now. And we are witnessing, or my research indicates that we are witnessing in practice how the current arrangements structurally undermine the independence and importance of the charitable sector in New Zealand. So even though it had a very long gestation process, the original Charities Bill that was introduced in 2004 was widely regarded as fundamentally flawed. The Working Party's recommendation for a Charities Commission was accepted, and the original Charities Commission was structured as a Crown agent, or the original Charities Bill provided for the Charities Commission to be structured as a Crown agent. By this time, there was overwhelming support from within the charitable sector for a Charities Commission and a Charities Register to provide a means for charities to demonstrate to anyone who was interested that they were worthy of support, and also to provide a means for weeding out rogue operators. However, while the concept of a Charities Commission had overwhelming support, there was considerable concern with specific provisions in the bill. The bill was based on the Companies Act and was heavily criticised for having been conceived in Treasury and designed by the Ministry of Economic Development. It was almost completely rewritten at Select Committee stage in response to hundreds of submissions, with further substantial changes made by supplementary order paper. The rewritten bill was not subject to proper consultation before being passed under urgency through all final stages on one day, 12 April 2005. The comment was made in Parliament that we do not really know what we are passing tonight or what the implications will be. However, concerns about fast law not making good law were assuaged at the time by then Finance Minister, the late Honourable Sir Michael Cullen, indicating that the Charities Act would be subject to a full first principles post-implementation review. And here we are, almost 2 decades later, and that is the review that we are still waiting for. The Charities Act, as passed, is replete with unintended consequences. These are some of the worst offenders, Section 5.3 and the words, for example, advocacy, which were added into the bill at Select Committee stage in order to reassure charities that their ability to advocate for their charitable purposes would not be affected. It is an example of a provision designed to help charities having precisely the opposite effect in practice, and it's amazing throughout the research how often that was the case. And at the beginning of Chapter 4 of the report, I've gone into some detail of the Greenpeace and Family First case studies, because I wanted there to be a record of how things have actually transpired in the interest of people drawing their own conclusions as to whether the current arrangements are working. Another set of unintended consequences relates to Section 10H and 18.3. In my view, the Charities Act is actually very clear about the distinction between purposes and activities, but apparently not sufficiently clear, because Charity Services interprets it effectively to conflate the distinction, for example, by requiring activities to be charitable. As I'm sure you're aware, charities law focuses on purposes. The concept of charitable purpose originated in trust law, where a charitable trust is an exception to the general rule that a purpose trust is invalid, with the exception only applying where the trust's purposes are charitable. Requiring activities to be charitable makes no sense in charities law terms, because activities only take their character from the purpose and furtherance of which they are carried out. So the focus on activities, often to the exclusion of purposes, has in practice fundamentally shifted the underlying axis of the legal regime. Many submitters to the government's review of the Charities Act commented on this phenomenon, which they described as purpose creep, and which I referred to in the report as a slow-moving change of underlying paradigm. The net result is that whether any particular charity is granted registered charitable status in New Zealand has become very subjective and even arbitrary. This factor has enormous implications for a liberal democracy. As Greenpeace noted in its submission, if the executive branch can control civil society institutions via the charities registration process, then we don't really live in a democracy. Another fundamental pillar of liberal democracy is the rule of law. Charities that meet the legal requirements for registration should be able to register without difficulty. And we're often told that Charity Services and the Charities Registration Board are just applying the law. And I would really encourage you to read these aspects of the report and draw your own conclusions as to whether assertions are correct. And if they're not correct, I think that we as lawyers have a duty to do something about it. Otherwise, we're effectively complicit in undermining the rule of law. Perhaps the key unintended consequence is the changes that were made to Section 59 at Select Committee stage, where the words District Court were crossed out and replaced with the words High Court, ostensibly to give charities a more fulsome right of appeal. But this is another example of a change designed to help charities that had exactly the opposite effect, because in practice it has had the effect of removing charities' ability to access an oral hearing of evidence altogether. And as the litigators amongst us will be well aware, cases are won and lost on their facts. Facts are established by evidence. Charities' inability to call and test evidence unduly favours the decision maker, and this has been a phenomenon in Canada, and it's now a phenomenon in New Zealand. It wasn't the case prior to the Charities Act. It's difficult because it makes it very difficult for charities to prove both what their purposes are and that they operate for the benefit of the public. And this factor has contributed significantly to the wider benefits that charities provide being consistently overlooked in New Zealand. And I think two prime examples of that are the cases in Canterbury Development Corporation and Queenstown Lakes Community Housing Trust. Social housing is a particular area of difficulty, and I would really encourage you to have a look at the social housing case study in Chapter 3. To my mind, preventing charities from providing affordable housing in the middle of a housing crisis is extraordinary. Reinstating charities' access to an oral hearing of evidence, in my view, is perhaps the single most important change the review of the Charities Act needs to make. A fair process that allows charities access to natural justice would do much to alleviate current difficulties. However, these are not the only bearers of unintended consequences. To make matters worse, in the 17 years since the Charities Act was passed, they have been characterised by a series of piecemeal amendments that have been similarly rushed through under urgency without proper consultation, often against the strong opposition of the charitable sector. Perhaps the most notable of these is the disestablishment of the Charities Commission in 2012, a very controversial change made against the strong opposition of the charitable sector and ultimately passing into law by only one vote. The hastily made changes grafted onto the original charities framework an unusual bipartite decision-making regime that appears to have been based on a significantly watered-down version of the Gambling Commission, which is also administered by DIA. I would encourage you to read Chapter 7 of the report and draw your own conclusions as whether the current bipartite structure of charity services in the Charities Registration Board is fit for purpose. One of the key difficulties is that when the Charities Commission was disestablished, all of the accountability mechanisms provided by the Crown Entities Act were correspondingly removed, but they weren't replaced with anything. Charities services are subject to almost no meaningful accountability mechanisms beyond minimal passing reference in a 200-page DIA annual report, which covers DIA's comprehensive work across a wide range of areas, including gambling, censorship, anti-money laundering, countering violent extremism, government record keeping, unsolicited electronic messages, etc., etc. In recent years, Charities Services has proactively produced its own annual review document, but such a document does not provide meaningful accountability because it only contains the information Charities Services chooses to include. As one submitter noted, it is not appropriate for a government service to be responsible only to itself. Another key difficulty relates to the purposes of the Charities Act. When the Charities Commission was disestablished, its functions of promoting public trust and confidence in the effective use of charitable resources were elevated to purposes of the Act. While clearly superficially attractive, the implications of elevating these functions to purposes of the regime in a jurisdiction where charities law is administered by an agency that is not independent and is not subject to meaningful accountability does not appear to have been fully considered. In practice, purposes to promote public trust and confidence in charities can become weaponized against charities because what might promote public trust and confidence is open to interpretation. Charity Services appears to consider that the way to public trust and confidence in charities is to regulate charities by means of increasingly restrictive rules and regulations that are expensive to comply with and administer and really only serve to stifle voluntary effort and distract charities from their charitable purposes. As John Tyler noted, regulatory purposes of ensuring effectiveness and accountability threaten to morph into overreaching exercises of governmental power in the name of enhancing public trust and confidence. Promoting public trust and confidence in charities has not proved useful as an overall purpose of the Charities Act regime, and every other jurisdiction that uses that phrase uses it as a function of the agency, of an independent agency, rather than as a purpose of the overall regime. It's an accountability mechanism for the government agency. A notable exception is Australia, who do have it as a function of the ACNC and also have it as a purpose of the regime. And when their legislation was going through in 2012 with that purpose in it, that may perhaps have emboldened the New Zealand legislators to make it a purpose of the regime in New Zealand. But it doesn't work as an end in itself. We don't want to promote public trust and confidence in charities so that we can admire it. Public trust and confidence is merely a means to an end. And one of the key recommendations of the report is that the Act clarify that actually what this Act is about is maximising charities' ability to provide benefit for society. And I recommend following the second object of the ACNC legislation adapted for a New Zealand context. I also recommend that the current purpose of promoting public trust and confidence is returned to a function of the agency responsible for administering the Charities Act. And I recommend that the purpose of promoting the effective use of charitable resources is removed because although while in principle it sounds reasonable, in practice, what constitutes an effective use of a charity's resources is a matter for those governing the charity to determine. It is not an appropriate function for government, and it's notable that a similar purpose was specifically rejected in Australia. And I also just wanted to mention the Charities Amendment Bill 2006, when the Department of Internal Affairs tried to remove the vast bulk of charities' rights of appeal by Statutes Amendment Bill over the Christmas period without consultation or even notification. Fortunately, the proposed amendment was noticed and ultimately removed from the bill due to strong objections from charities. And it then became Labor Party policy for the 2017 election to consult with the sector on whether the disestablishment of the Charities Commission has resulted in effectiveness and improved services for the sector, to prioritise the long-promised review, beginning with a first principles review, including examining, updating and widening the definition of charitable purpose, and ensure that community and voluntary organisations can engage in advocacy without fear of losing their registered charitable status. This policy is significant because not one of these issues is being addressed by the current review. So as we know, Labor won the 2017 election and formed a coalition government. But interestingly, Labor's spokesperson for the community and voluntary sector and the author of Labor Party policy in this area, the Honourable Porter Williams, was not given the portfolio. Instead, the Honourable Peeni Henare was appointed minister. It is common for the community and voluntary sector portfolio to be given to a new minister outside cabinet. In November 2017, the new government convened a tax working group chaired by the Honourable Sir Michael Cullen, who had been Minister of Finance during the passage of the original Charities Bill. The tax working group was tasked with examining improvements in the tax system and specifically whether New Zealand should introduce a capital gains tax. Their terms of reference are entirely silent on the topic of charities, and the interplay between the tax working group work and the Charities Act review provides important insights into charities regulation in New Zealand. Although the terms of reference were silent, the tax working group made recommendations regarding charities nevertheless, primarily relating to business activities and accumulations, which recommendations were then kicked for touch to the review of the Charities Act. That review was announced contemporaneously in November 2017. However, the terms of reference for the Charities Act review surprisingly did not honour Labor Party policy. There were considerable concerns regarding the attenuated nature, scope and timing of the review. For example, key issues such as the definition of charitable purpose were specifically out of scope, and the DIA was effectively tasked with reviewing itself. In addition, the new minister wanted the review, including legislation, to be completed before the 2020 general election, which would have required all policy work to be completed within a very short time frame of only a few months. Interestingly, we requested to meet with the new minister, but we were not granted a meeting until the very day that the very attenuated terms of reference were released in May 2018. The DIA issued its discussion document for the review in February 2019, following which public consultation took place. Concern about the attenuated terms of reference for the review led a number of philanthropic funders to gather resources to provide funding to two core reference group members, Dave Henderson and myself, to help ensure sector input into the review. With this support, and also thanks to the support of Minister Henare, Dave Henderson and myself were able to attend, speak and listen at all 27 consultation meetings for the review between us held around the country during March and April 2019. Our aim was to provide an alternative perspective to government on the review, but most importantly to encourage charities to make a submission. Charities did make submissions, 363 of them in fact, which is a fantastic response. The submissions are to some extent limited by the attenuated nature of the terms of reference, which flowed through into a very narrow range of questions on which the DIA's discussion document sought responses. As one submitter put it, the discussion document, and I quote, appears to be leading submitters to concentrate and respond on what DIA thinks is important rather than cover what the individual charities are concerned about. Even so, many submitters did not limit their comments to the questions asked by DIA, and it is clear from submissions that there is a significant disconnect between DIA and the charitable sector on how the current framework of charities law is or is not working and what changes need to be made. Key issues that come through strongly in submissions include the need to do the review properly, as well as the 3 A's, appeals, advocacy, and agency structure. The submissions are a rich source of information. In preparing the report, I have reviewed all 363 of them, and in the report itself, I have very much tried to highlight the submissions so that the reader can hear from charities in their own words. The disconnect appears to have put the minister in a difficult position. Listening to the sector appears to have put the minister into conflict with his DIA officials. Who knows what went on behind the scenes, but a few weeks later, in July 2019, there was a change of minister, and the Honourable Porter Williams, the author of Labor Party policy in this area, was appointed. We asked to meet with the new minister, but we were not granted a meeting for several months, until the day, in fact, that it was announced that the review of the Charities Act was now being telescoped into just 3 issues, in direct contrast to Labor Party policy that Minister Williams herself had written in consultation with the charitable sector. As far as I am aware, there was no consultation with the charitable sector, certainly not with the core reference group, prior to announcing that the review would be narrowed to these 3 issues. While the issue of reporting requirements for small charities was definitely a key theme of the community engagement meetings, the issues of charities' business activities and accumulation of funds appear to have come directly from the tax working group, ahead of issues of concern for the charitable sector. But then COVID struck and their review was paused. Labor was successfully re-elected in the October 2020 election, and this time with power to govern alone. In November 2020, there was another change of minister. The minister is now the Honourable Priyanka Radhakrishnan, another brand new minister outside Cabinet, and the third minister since the government's review of the Charities Act began. We again asked to meet with the new minister, but again we were not granted a meeting for several months until the day, in fact, that it was announced that the review of the Charities Act was now being telescoped into 5 issues. In May and June last year, the DIA prepared a series of initial policy papers in relation to these 5 issues, which were circulated for targeted consultation, including with the core reference group. The policy papers have not been placed on the DIA website. However, we specifically asked and were told that they are not confidential and we may use them as we choose. In October 2021, DIA's website was updated to say that themes from the discussions and the submissions will likely be provided on this webpage following consideration of the policy proposals. If the Cabinet paper is approved, it will be proactively released within 30 business days, likely to be early 2022. Well, it's early 2022 and we haven't heard anything yet. It's basically radio silence. But there was discussion at the consultation meetings and there have been murmurings that the next step might be the introduction of a Charities Amendment Bill into Parliament. The report for the fellowship was released last month on 19 April 2022. Its key recommendation is that the government's review is transferred to the Law Commission for an independent and ideally multidisciplinary review, taking into account the wider legal framework for charities, including the Charitable Trusts Act, the Trusts Act, and the Incorporated Societies Act. Any review of the legal framework for charities must extend to issues of concern for the charitable sector, including the definition of charitable purpose, advocacy, agency structure, the wider legal framework, and government contracting. If the Law Commission is not available, and I understand that they're very busy, other jurisdictions such as Australia, Northern Ireland, and England and Wales have adopted the independent panel model. We also strongly recommended Recommendation 8.37 that no further piecemeal amendments are made to legislation affecting charities pending such an independent first principles review. Further piecemeal reform entailing alterations to isolated aspects of an interconnected system is very unwise. Any proposals for charities law reform must proceed as a whole, and then only with caution and after substantial further consultation. Further specific consultation with Māori is essential. We sent a copy of the report to the Minister and have asked for a meeting. We also sent a copy of the report to the DIA. So far, we have not received a response from the Minister to our request for a meeting, but we have seen reports in the media that a charities bill is proposed to be introduced into Parliament later this year. I understand that these comments were made before the report was released on 19 April. As part of the research, I wrote an article for Third Sector Review entitled Charity Regulation in New Zealand History and Where to Now, which looked at the interplay between the work of the Tax Working Group and the Charities Act Review. I am very concerned that any such charities bill will be followed by tax legislation, potentially removing charities' exemption from income tax for business income, potentially as a precursor to removing charities' exemption from income tax altogether. My key request is, could they please take account of the report before making such decisions and taking such steps? And it's interesting to note in this context or to compare the approach taken to charities law reform with the approach taken to the Incorporated Societies Act, which was passed into law last month. The Act is the culmination of an extensive review process lasting some 12 years, which included the release of an exposure draft bill in 2015. In other words, the need for a highly consultative process in the area of not-for-profit law was recognised in the context of New Zealand's approximately 23,000 incorporated societies. It is important that the need for a similarly consultative process for New Zealand's 28,000 charities is similarly recognised. Because I was just working through what the worst case scenario might be. We have no visibility at this stage as to what such a charities bill might contain. But if the Minister were to continue along the lines revealed by the consultation undertaken last year, Such a bill is likely to implement a substantial increase in charity services regulatory powers, despite an absence of empirical evidence of a need for such powers, and with no corresponding checks and balances on such power. The comment about addressing practical day-to-day process and transparency issues faced by the charitable sector to allow charities to focus on working with communities, with great respect, is very misleading. Indications to date are that any such bill will not address any issues of concern for the charitable sector and will most likely act perversely to preclude the sector's real issues from being addressed. And removing charities' tax exemption for business income would directly conflict with the government's stated objectives of creating an enabling framework for social enterprise. All of this would make it more difficult for charities to carry out their work at a time when their work is never more needed. As discussed in the report, if the Canadian experience is anything to go by, once unhelpful legislation is in place, it can be many decades before it is able to be turned around, if it ever is. Canada is described as having been on a 40-year odyssey, and only now, with recent developments such as the appointment of the Advisory Committee on the charitable sector starting to turn some very unhelpful legislation that has been in place for decades around. Wouldn't it be nice if we could learn from the experience of other jurisdictions and not make the same mistakes in the first place? The New Zealand charitable sector has a very good track record in having unhelpful proposed legislation turned around at select committee stage. And even though Labor currently has an absolute majority, I'm sure the Minister would not want to put herself into conflict with the charitable sector in the lead up to the 2023 election. Because moving ahead with such a series of piecemeal amendments in advance of a proper first principles review would cement the underlying paradigm of charities law in favour of restricting charities rather than enabling their work. In the report, I talk about what I see as an underlying clash of paradigms that permeates this area of law. It manifests itself in a number of ways, and these are just some examples. But broadly, one paradigm sees charities as a fiscal cost. The fact that they receive tax privileges is somehow seen as turning their funds into government funds over which government should be able to exercise almost complete control. This paradigm sees charities effectively as a service delivery arm of government and aims to restrict what charities can do and what they can say so that they are effectively limited to furthering government objectives only. Interestingly, this, I understand, is the policy of the Chinese Communist Party in relation to its charity law, which was passed into law in China in 2016, a policy which Mark Siddell describes, and he has specifically authorised me to quote him on this, as more third sector and less civil society. This approach is based on a view of the charitable sector as purely service-orientated, with a role limited to taking over social services from government or contracting with government to provide services. In other words, no advocacy. The other paradigm sees charities' independence as their hallmark and critical to what makes them distinctive and valuable. Charities enable people to come together in furtherance of a shared purpose, free from the dictates of the median voter or profit-seeking shareholders. Charities' independence from government enables them to take risks, experiment, innovate, and reach into communities in ways that government cannot. Charities are also untethered to electoral cycles, potentially enabling them to address issues on a longer-term basis than governments. Under this paradigm, charities are seen as the eyes, ears, and conscience of society, with an important role in holding government to account. The independence of charities has been critical in many important societal changes that have been achieved over the centuries, including the abolition of slavery, universal suffrage, anti-smoking laws, and many, many others. This paradigm sees charities' right to mana motahake, or self-determination, within the bounds of charitable purpose, as an important manifestation of liberal democratic values. The diversity of the charitable sector allows for authentic expressions of pluralism, democratisation, and localism as people come together to address issues they see arising in their community, which issues may not even be on the radar of government. Many solutions are needed to the complex and connected challenges that we face. Government cannot do everything. Communities know best what communities need. In other words, at the risk of oversimplification, one paradigm seeks to restrict charities and the other seeks to enable their work. It would not make sense to cement a restrictive paradigm before we have even had a chance to really have a look at which paradigm would be most appropriate for New Zealand, a country with a government focused on well-being and with a project to bolster social cohesion. The potential for charity help in almost every area government wants to focus on, including child poverty, health, education, rising inequality, climate change, etc., appears to have been entirely overlooked. And if we get charities legislation that cements a restrictive paradigm, what are the chances of it being turned around? Sadly, the narrow paradigm contributes to charities being seen as anachronistic, a deficits-based, paternalistic, colonialist concept of handouts to the poor, limited to assuaging need and therefore forced to wait until people have fallen off a cliff before being able to help them. In other words, the narrow paradigm contributes to charities being seen as symptoms of the problem rather than a key part of the solution. Yet when the definition of charitable purpose is interpreted correctly in accordance with New Zealand law, it is not at all so limited. It is strengths-based, capable of embracing innovation, prevention rather than merely cure, and supporting human flourishing in its many manifestations. The best illustration of this in New Zealand case law, in my view, is the trilogy of cases in the Latimer litigation, the Crown Forestry Rental Trust cases. And I have discussed the factual background to the Latimer litigation in some detail in the report because it's quite unique, and not all of it is actually in the cases themselves. And I think this may have contributed to the Latimer cases being overlooked. For example, cases such as Canterbury Development Corporation and Queenstown Lakes Community Housing Trust do not mention or refer to the Latimer cases and are, in fact, inconsistent with this prior higher authority. The narrow paradigm is playing out in increasing authoritarianism around the world. Since the 9/11 terrorist attacks on the US in 2001, there has been a wave of charities legislation around the world, and charities law frameworks are being used as a tool for suppression of not-for-profit advocacy. We are witnessing crackdowns on dissent and a shrinking space for civil society around the world. The number of democracies backsliding into authoritarianism has doubled in the past decade, exacerbated by restrictive measures adopted in response to the pandemic. According to the 2021 Civicus Monitor, 90% of the world's population, 90%, is now living in countries rated as closed, repressed, or obstructed. Even Australia and much of Europe is rated as narrowed. Add to this forces at work trying to destabilise democracy from within. Professor Haight argues that this century is becoming a contest between open societies, the West, and closed societies, China and Russia. China has expansionist ambitions. It is aggressively expanding its authoritarian influence overseas, as we can see in countries like Myanmar, Solomon Islands, Samoa, the Philippines, Hong Kong, and so many others. It may use education as a tool in this regard, and I was very surprised in carrying out the research at how many people were questioning whether freedom of expression, even democracy, was something even worth having. In my view, a world-leading framework of charities law in a liberal democracy like New Zealand would boldly uphold liberal democratic values, including protecting charities' ability to advocate fearlessly for their charitable purposes. Because a restrictive command and control paradigm is expensive, not only in terms of compliance, administration and litigation costs, but also in terms of hidden costs such as damage to independence, goodwill, trust and confidence, and New Zealand's culture of volunteering. Over-regulation works against participation and progress, including opportunities to be innovative and responsive. It is important to note that after 14 years and many millions of dollars worth of regulation, public trust and confidence in charities in New Zealand has in fact declined. I know that such surveys have their limitations, and I also am not convinced that public trust and confidence is the ultimate purpose or the best purpose for a Charities Act regime. But while public trust and confidence is undoubtedly important, it is not clear that heavy-handed regulation is the best way to achieve it. Research indicates that public trust and confidence in charities is driven by charities themselves, and most particularly by their purposes. It does not derive from regulation. To the contrary, over-regulation can diminish trust and confidence in charities by creating suspicion that such regulation must be needed when that may not in fact be the case. We saw during COVID lockdown how effective and efficient a trust-based approach can be. In an unsettled world, the best way to protect against increasing polarisation and extremism is to bolster the bonds of community and democracy. Social cohesion is critical to preventing the development of harmful, radicalising ideologies, to strengthening resilience to the narratives of hate and division, and thus to preventing downstream violent extremism. It is often said that much like a virus, disinformation spreads through susceptible hosts. Democratic principles such as social tolerance, trust, and the rule of law act as a vaccine to the hateful and racist ideologies that are dedicated to destabilising democratic principles and destroying such norms. So in designing a charities law framework, consideration must be given to protecting charities' important role in a liberal democracy and the need to uphold liberal democratic values of social tolerance, freedom of expression, freedom of association, and the rule of law. Regulation cannot be an end in itself, and we must take care not to create regulation for regulation's sake. At the very least, we should be conscious, open, and consultative about which paradigm we are choosing and why. So it's probably no surprise that the report concludes that New Zealand should enact an enabling framework for charities, that we should choose the enabling paradigm. Charities are fundamentally private organisations, and their tax privileges do not turn them into organs of the state. And this was specifically recognised in the Incorporated Societies Act, Section 3D3, which says that societies are private bodies that should be self-governing in accordance with their constitutions and free from inappropriate government interference. Because charities are already subject to a high degree of regulation, whether it be through criminal law, tax law, anti-money laundering legislation, health and safety legislation, financial legislation, legislation relating to the safety and well-being of children, etc. It's not clear that charities require another layer of heavy-handed regulation by means of the Charities Act, simply because they are charities. The Ontario Law Reform Commission argued that it would be a mistake for government to lose sight of the core values that motivate charitable endeavour by adopting a regulatory approach that is too heavily reliant on command and sanction as opposed to mutual respect and persuasion. The recent review of the Charities Framework in Northern Ireland expressed a similar sentiment, noting the importance of developing a framework that recognises the goodwill and willingness of most charities to comply. Prior to the Charities Act, it was difficult to enforce the fiduciary duties that all those that govern charities owe due to the lack of information. But now that we have the information provided by means of the Charities Register, it behoves us to use it, to enforce the fiduciary duties and rely on the scrutiny of 1,000 eyes, because no government agency is ever going to be able to regulate all 28,000 charities on the register. But actually, when you look at the fiduciary duties, charities law provides sufficient accountability. So the key recommendation in this regard in the report is that the Charities Act should provide for one overarching fiduciary duty. So this is a mix of the duty of loyalty and the duty of obedience. And this wording was reached after a series of workshops organised by Dr. Ian Murray and Dr. Rosemary Langford with international charities law specialists from around the world. So every registered charity and every responsible person of a registered charity has a duty to act in good faith to further the stated charitable purposes of the entity in accordance with its rules. So this draws on the fact that purpose is the key underlying driver of trust and confidence in charities. Restoring a focus on purpose would inherently respect the independence and autonomy of charities by holding people involved with charities to the purposes that they have signed up to. A focus on purpose would not ask whether any particular activity is charitable, or how much of any particular activity is acceptable, but whether any particular activity is carried out in good faith in furtherance of the charity's stated charitable purposes. Such an approach is simple and easily understood, so it provides certainty for charities to confidently further their charitable purposes within clear parameters, while also providing inherent flexibility to cater for the wide variety of ways in which public benefit might be furthered. It also provides a clear basis for oversight of charities' activities, while also respecting their independent private nature and the equitable origins of charities law. It would therefore protect against harmful regulation that risks inhibiting innovation and stifling or demoralising voluntary effort. And it would enable significant administration, compliance and resource cost savings to be made and pave the way for an enabling light touch, cost-effective regulatory framework that would encourage charities to thrive without compromising necessary safeguards. So you may have seen, if you've had a chance to have a look at the report, that Chapter 9 of the report includes a draft bill that would amend and restate the Charities Act, and it implements this recommendation and the recommendation to enact an enabling framework. Now, I'm conscious that I'm running out of time, but basically, just to move quickly, there are 70 recommendations in the report, and I won't have the opportunity to go through all of them, but I think that the draft bill also aims to clarify fundamental principles, such as how a charity's purposes are ascertained and the test for whether a purpose is charitable. And Australia has a significant advantage in that regard because the test for whether a purpose is charitable is set out in the legislation, so that considerably reduces the scope for subjectivity and discretion. I think we also need to clarify that the test for whether a purpose is charitable applies to all purposes, irrespective of whether advocacy is involved. We've currently got this ends, means and manner test whenever advocacy is involved, which fundamentally shifts the underlying legal axis from one based on purposes to one based on activities. No other jurisdiction uses that approach, so it is putting New Zealand out of step with the rest of the common law world in terms of advocacy by charities. We need to clarify that the charitable purpose test applies to activities and that doesn't apply to activities or to the entity. And I recommend following the model of the Trusts Act and specifically preserving recourse to equitable principles. I recommend that the legislation clarify that activities are assessed to determine whether they are carried out in good faith and furtherance of the charity's stated charitable purposes. If that test is met, there is no reason for the state to become involved. If a charity can't demonstrate that, then there is a clear basis for intervention. And I also think we need to clarify the purpose of the legislation to set guardrails for decision-making and clarify the lodestar. There's a whole lot of other measures I recommend, specifically reinstating access to an oral hearing of evidence. I think that's critical for the common law to work as intended, to have access to the time-honoured mechanisms of the common law for establishing facts through evidence. I think we need to, I specifically consulted with Justice Joe Williams following a speech he gave to the Charity Law Association conference in 2019, I think, called Pemsel in the Pacific. And I approached him to ask how we might infuse tikanga principles into New Zealand charities law. He very kindly convened a team of tikanga experts, and we met by Zoom over lockdown in 2020. And the draft bill in Chapter 9 of the report is intended to implement the results of that consultation faithfully. I think it is important that we establish an agency that is genuinely independent and accountable and that reports to Parliament, require public consultation before guidance is issued, provide a means for charities to have meaningful input into policy, and a number of other recommendations such as making better use of the data on the register, a civil society strategy so that we actually have a clear idea of what we are trying to do and maximising the ability of charities to help, and expand the Schedule 32 guidelines because the overseas donee status guidelines are limited to international humanitarian aid obligations, and a number of submitters made the point that issues such as pandemics, climate change, etc., know no borders, and while they might not fit into international humanitarian aid, charities should be encouraged to support those efforts internationally and not limited to domestic, and still maintain their donee status. I recommend only 3 restrictions on advocacy by charities: those contained in the general law, those contained in the charities constituting document, but otherwise charities may be political, but they may not be partisan. And there is consensus around the common law world that this is a restriction on charities advocacy, but as far as my research indicates, there is no reason for any other specific limitation on charities' activities beyond these restrictions, just because they're charities. I think we need to encourage charities to be running businesses. Charities running businesses are, by definition, social enterprises, and they have built-in advantages such as their charitable purposes, so they have a built-in mission lock, and they also have these financial reporting rules. New Zealand charities are subject to what appears to me to be the most comprehensive set of transparency and accountability requirements in the world. And I think we can deal with business activities by enforcing the fiduciary duty. Charities are subject to the destination of funds test and a non-distribution constraint. All funds must, by definition, be destined for charitable purpose, and nobody can make a private pecuniary profit from a charity lawfully. In other words, the common law contains built-in protections against anything that might concern us in relation to business activities, and I think we should use them rather than trying to create complex ex-ante rules. And I think we also need to be careful with terminology. I really think we need to move away from the terminology regulator, because and certainly in New Zealand, in a jurisdiction with very little accountability and an agency that is not independent, it is creating a climate of encouraging regulation and regulatory overreach, whereas actually the Charities Act, Section 23, says that Charity Services is a registrar, not a regulator. Anyway, that's a very quick whistle-stop tour, and hopefully I have left at least a little bit of time for questions.
Thank you very much, Sue. A couple of comments, and then I'm going to ask people to put their hands up using Zoom technology to ask them questions. First of all, I just wanted to say that presentation just demonstrated what I said in my opening remarks, your energy and passion for the area. Thank you so much for sharing that with us. I think it also shows the faith that the foundation had in supporting you through the fellowship. There's an awful lot of work that needs to be done in this area, at least in New Zealand. And I suspect anything done in New Zealand, from what you say and my own knowledge, will have an impact on what happens overseas. So everybody on this Zoom should be concerned about what's going on. I think it also is a strong signal to those involved in the charity sector, and that includes their advisors in particular, about what lies ahead. And the fact that, as you say, you know, if we sit back and don't participate, then we've got coming to us exactly what is coming down the line. It is only by being active and getting ahead and participating that wrong turns can be avoided. So listen, they were my remarks. I'm looking around for hands up, and I saw Ian, you had your hand up. So I will ask you to put your question